When parties get divorced and they are married according to South African law, normally the end result is that they enter into a so-called settlement agreement or consent paper. This is basically a legal document which deals with the custody issues, the division of the assets, and so on. It often happens in my practice that clients come and consult me and they say that they were never legally married and they wanted to know what their rights are. They ask me, is there such a thing as a common law husband or wife? The reality of the matter and the answer to that question is there's no such thing in South African law as a common law husband or wife. Sometimes you simply do not have a claim. If you're living with somebody and you did not officially legally get married, you often do not have a claim. In certain situations, however, a so-called universal partnership can be proven, where parties are not married together, they are not married legally, but they can still share in the division of the assets at the time of the solution of their relationship. In order to prove this would be, for example, a universal partnership would, for example, exist where one person owns a business. The man, for example, runs a business, he owns the business, and the wife does have some kind of contribution towards the well-being of the business. So they are both actually actively involved together in the operation of the business. In a situation like that, if there was a breakup between the two parties, the wife may claim that there was a universal partnership, and the courts in that kind of situation may allow the wife to share in assets which are not registered in her name. In order to prove that there was a universal partnership, there have to be certain factors that are present. The leading case on this is that of Pizzuto versus Dreyer. It is a very common case for students, university students, when you're studying the law in this regard. The Pizzuto case sets out 4 requirements in order to prove that there was a universal partnership. Those requirements are that each of the partners brings something into the partnership, the business is carried on for the joint benefit of the parties, the object of the partnership should be to make a profit, and the contract should be a legitimate one. These 4 points from the Pizzuto case were later confirmed in the 2012 case of Ponelat versus Schroepfer. So it is also important when parties do not plan to get married but merely to live together that they enter into a so-called cohabitation agreement. This is similar to an antenuptial contract where parties get legally married, except that they are not getting legally married. They are merely entering into a cohabitation agreement which would deal with what the consequences would be if there was a breakup in their relationship. Sometimes in these agreements, there is a clause drafted by an attorney attempting to exclude a cohabitation agreement. There may be a clause, for example, to exclude a universal partnership. There may, for example, be a clause that if there is a breakup in the relationship, there will be no universal partnership. Parties must be very wary of that kind of clause, as it is a wicked clause and you're basically writing off all of your rights if there is a breakdown in the relationship. I believe that I personally believe it's very important to have everything put in black and white. And when parties get married, for example, I believe that they should each consult their own attorney to peruse the antenuptial contract that was drafted. Similarly, with a cohabitation agreement, it is in their interest to consult their own legal representative. That is all I have to say on universal partnerships.